Good morning, everyone. My name is John Mayo. I am a professor of economics, business, and public policy at Georgetown University's McDonough School of Business. I am also the executive director of the Georgetown Center for Business and Public Policy, which today is co-hosting with Cornerstone Research this event. I will tell you that this is the fourth in a series of Georgetown on the Hill events that are being done under the banner of New Debates and Tensions in Antitrust. The first three of those are memorialized on the Georgetown Center for Business and Public Policy website. You're welcome to go see those. They were on the future of antitrust, on antitrust in high-tech industries, and antitrust in platform industries. Today, what we want to do is turn to the discussion of the 2020 vertical merger guidelines, which were just released in June. And we are really excited about the idea of doing this event at this moment in time for at least a couple of reasons. Number one, the guidelines are incredibly fresh. They're brand new. The ink is not really dry on the paper that they were written on. And while over time, they're going to surely get better defined, more rigidly interpreted, right now, we have an opportunity, because of their freshness, to help shape that narrative, to help shape the understanding and interpretation of how these guidelines are going to proceed. And that's a very exciting opportunity for us today. It's something that we can do today. We couldn't do or not do as effectively 6 months or 6 years from now. So we're very excited about that. The second reason I think we're excited about this is, and I don't need to really tell this audience this, the discussion of antitrust is today more prominent than it ever has been in any of our professional lives. And the guidelines being published just recently represent maybe the latest signal or the latest data point, if you will, in our understanding of the trajectory of antitrust policy, which is something that we care very, very deeply about in this country. So we're very, very excited. I think this is a tremendous opportunity for us to shape the narrative and to understand where antitrust is headed. Now, the way we're going to proceed is pretty straightforward. I will introduce in a moment our keynote speaker. We'll have some opening remarks. We will then turn to a panel discussion of renowned economists and lawyers. I will moderate a set of Q&As for that set of panelists. And then, like all Georgetown on the Hill events, you'll have an opportunity to ask questions yourself. Now, we've got a lot of people on the call on the in the event today participating. So the best way for us to manage that process is simply for you to use the button on the bottom of your screen that's a Q&A button. And if you'll use that as a question dawns on you for the panelists, please just go ahead and type your question. My colleague at Georgetown, Professor Jeff Macker, will curate those questions and then pose those questions to the panelists toward the end of the event. So it's pretty straightforward. Now, without further ado, let me introduce you to our keynote speaker. It is a tremendous thrill for me to introduce to you Senator Amy Klobuchar. Senator Klobuchar is the senior senator from the state of Minnesota. Senator Klobuchar has a distinguished career of public service to both the folks in Minnesota and to the United States writ large. We owe her a debt of gratitude for her public service. Thank you, Senator, for that. We really appreciate it. Not only has Senator Klobuchar been an active public servant for a long time, but she also, in my mind, represents a role model for people in Congress. In an era that is all too often characterized by partisan bickering, she has shown herself as a role model of being able to elevate above that bickering, to bring together people from across the ideological spectrum, to fashion public policies and public legislation that move us forward smartly. And so for that, we can only hope that your leadership spreads, and pardon the pun, like the coronavirus.
Okay,
That's the best. You had to get a coronavirus joke. You knew it was going to come.
Coronavirus, no.
I hope your leadership spreads like the coronavirus. Let me be very clear about that. So I would also be remiss if I didn't say that Senator Klobuchar also plays a leading role on the Senate Judiciary Committee, and is the ranking member of the Judiciary's Subcommittee on Antitrust, Competition Policy, and Consumer Rights. Senator, it is a privilege to have you here, a wonderful honor to us to have you here. We're delighted. We look forward to your remarks on competition policy, antitrust, and the new vertical merger guidelines. Senator,
all right.
The floor is yours.
Well, thanks so much, Don. That was a memorable introduction. It will go in my pantheon of memorable introductions. One of my favorite was I've been introduced 3 times by people who are a bit nervous and who are about to say in my home state to huge crowds, and I give to you Minnesota's senior senator. And guess what they say? I give to you Minnesota's senior citizen. Anyway, but I'm not putting it in that group, but and I'm excited to be speaking to Georgetown on the Hill. My husband actually has been an adjunct professor. He's a law professor, expert on the death penalty, and he teaches the death penalty class at Georgetown, and has done that for nearly a decade, and loves teaching there. So thank you for including me. I hear we have hundreds of people on the call, and that is like the best thing I ever heard, because my goal in life as we head into what I hope, and I'm not going to be all political here, but my view is a new administration, that we will make antitrust cool again. This is our plan. And I know your panel, I especially want to mention a former acting assistant attorney general, Hesse, who I know is on the call, and everyone who will be on the panel involved in this, because we are, as you know and mentioned, are in the midst of a global pandemic, which has infected millions of Americans, killed thousands. My husband got very sick, was in the hospital for a week. And yet my dad at age 92 in his assisted living somehow got through it by just losing 10 pounds, and that was it. And so we know it's hitting everyone. And one of the things that has brought antitrust to the forefront, and I'm not saying it wasn't going on for decades here with conservative court rulings that made it very difficult to bring cases, with mergers, record number of mergers, but the pandemic has really put a big fat magnifying glass on antitrust issues, as we're seeing small businesses closing left and right. Some of them, I hope, temporarily, but some of them we know permanently, and it's created incentives for consolidation all over the place. I just, with Senator Cornyn, became bipartisan, introduced a bill about these small music venues all over the country, because while Ticketmaster / Live Nation, which merger involves some significant antitrust concerns, are able to buy venues all over the place, and during the pandemic got a $500 million investment from Saudi Arabia's sovereign wealth fund. Little First Avenue in Minnesota, where Prince would not have been Prince without it, is not getting that kind of investment. And in fact, all the small music venues were already floundering because of the consolidation we're seeing, and now they have the pandemic. So I just bring that up because it's timely, not nearly as timely as the tech hearing that my friend David Cicilline headed up yesterday with the major CEOs. How much would I love to have that gavel in the coming year, so we could have similar investigations and hearings. But I thought that a lot of light was shed on some of the issues with tech from that hearing. And my focus is, yes, getting interest in this issue, but then getting action. You simply can't freeze the antitrust laws where they were decades and decades ago, when we have all of these new companies and new business models like you see with Amazon and the like. One of my favorite latest examples was Uber Grubhub. And when that proposal was made, of course, it was batted down, and they then went on to try a different merger. But Uber Grubhub, their proposed merger would have made that combined company of Uber Eats Grubhub and DoorDash, the next biggest one, control 90% of the home delivery market. And now with the new Uber Postmates merger, it would be 75%, the two companies when you add in DoorDash. And so those are what lead a lot of us to be really concerned about what my friend David Cicilline called pandemic profiteering during this time. But I really want to make it clear that it's not just about that. And it's not just about what we've seen in the last year. It is about everything from agriculture to online travel, where people think they're getting all these choices. And in fact, it's two companies that own nearly all of them, or 90% of them. What we've seen in pharmaceuticals, something I've worked on for a long time and got to speak about several times on the presidential debate stage. But it is time for a change in the law. So when you go back in history, you know, all this started with actually the founding fathers, and the Boston Tea Party is always known for its emphasis on taxation without representation. I've had several discussions with Mike Lee and Ted Cruz about this, but in fact, it was also about monopolies. So many of our early settlers and pilgrims and others came over because they wanted to be free, not just religiously free, of course that was important, but also free to start their own businesses and be entrepreneurs and not be dependent on having to buy their tea from the East India Tea Company, as was the case there. And then you fast forward, you see a number of the founding fathers talking about antitrust, trying to put provisions in the Constitution, with others pushing back and saying, no, it'll take care of itself, with Adam Smith talking about his fear of the standing army of monopolies. He was kind of our economic guru at the time. And then you move forward and you finally see, with the monopolization and the consolidation and the robber barons, the Grangers in the Midwest and the unions in Chicago and elsewhere around the country, pushing back on the effects of a lack of enforcement and a lack of any real antitrust laws with teeth, to push the issues of income inequality. I'm saying all this because I want you to think of our current situation right now. Income inequality and a lack of choices and being squashed down when you're a small business. And they literally went to, with their pitchforks, to barns out in Minnesota and Iowa. Iowa had the first antitrust law that was not just about one commodity, and took to the streets. The unions did in the time of Eugene Debs in protest. That's what was going on back then. And out of that came Republican authoring the Sherman Act, the Republican Ohio Senator, Senator Sherman, and then of course, Teddy Roosevelt, and later enforcement efforts by presidents after that. Then we get into the last 100 years or so, where it's come to be dominated by some very well-meaning people, I know, but it's the whole area has tended to be dominated by economists, thank you guys, as well as lawyers and law cases and all of the exemptions. Some good laws passed after the Sherman Act with the Clayton Act and other bills that made it very clear that the antitrust laws were not about going after co-ops or about unions, which initially happened, but in fact, they were going after consolidation. Then you have the buildup in the Justice Department and the work on the AT&T merger and the obvious positive consumer outcomes from that with the rates and the like. I bring all this up because sometimes I feel like everyone, when they look back at their lives, as I try to capture this issue to make it more real, can trace their lives in America back to some type of economic policy and decisions that were made. In my case, my relatives my grandparents actually came from Switzerland. My great-grandparents on my dad's side came from Slovenia, and they were recruited by the rails to come over and mine ore. And when I was growing up, fast forward decades and decades, my mom would take me at Christmas to go by the James J. Hill House to see the lights. Well, our family metaphorically built that house because my family had been the labor that was used to support the monopolists. Now they wanted a better life, and a lot of good things came out of their decisions to work every day and go down 1,500 feet underground, my grandpa, in that mine. And it made a better life for my dad and certainly for me. And that's America. But at the same time, because there was pushback and antitrust laws and union organizing, those mines got safer, his wages got better, and he was able to do that. So that's the history. And that's why I then, when I went into private practice, actually, guess what I represented? MCI, and was there when we were taking on the monopoly phone companies and did that for years and years and years. So I've had a front row seat, ending, of course, right now with my current job with the Antitrust Subcommittee. So that's how I see this history, and it fits in now. Look at the increase in income inequality. A Wall Street Journal analysis showed that the median compensation now for 132 CEOs of S&P 500 companies was 12.4 million in 2018, but the wages of American workers have not kept pace with the growth in productivity, not by a long shot. From 79 to 2017, a February 2019 report of the Economic Policy Institute notes productivity grew 70.3% from 79 to 2017, while hourly compensation of production and non-supervisory workers grew 11%. CEO compensation grew from 78 to 2018, 940%, while wages grew 11.9%. So you've got that. Everyone knows this is a fact. You've got the stifling of new business creations, the startup slump, the number of new businesses, this is pre-pandemic, has fallen sharply in recent years, with CNN noting in 2016 that 452,000 firms were started in 2014, a number far below the 614,000 starting in 2006. We have less and less workers working at small businesses. And all of that means less innovation in the long haul and stifled competition. I remember being at a small town, Albert Lea, Minnesota, at a diner after a day out in my state. And this woman who was sitting with her farmer husband and her brother-in-law, who was also a farmer, turned around and said to me, I just saw you on TV, it was good. And at the time I was doing a bunch of interviews nationally on Russian interference in our election. I said, oh, was it about Russia on the national TV? And she said, no. It was on our local TV. It was about things getting too big. So it's hard for us to be able to make it. And I think that is a pretty good way to talk about it and a pretty good way to think about it as we head into what I believe is going to be a record year next year of lawmaking when it comes to antitrust. As we saw yesterday, when we saw the CEOs of Google, Facebook, Amazon, and Apple, there is significant concern about anti-competitive conduct by dominant firms, particularly on digital platforms. These powerful digital tools let us do extraordinary things, especially during this coronavirus, and we know it. But it also means that just a few companies have a lot of power over our personal data, power over what ads we see, what news we watch, and of course, increased market power. That's why I've repeatedly called for investigations into the conduct of the dominant digital platforms, things like looking back over the Instagram, WhatsApp purchases of Facebook, things like looking at monopsonies. Apple, Microsoft, Amazon, Google, and Facebook combined have completed more than 700 acquisitions since 1987. And it's easy to say these deals are only troubling in hindsight and that the agencies could not have predicted what would have happened. But for many of these acquisitions, concerns were raised right away, and they were just allowed to go through in part because of what? Not enough resources in some of these departments to go after these sophisticated companies and investigate them, in part because they say, okay, look at these court rulings, it won't matter if we do anything about it anyway. And of course, in part because of the way the law exists now, that it is not as easy to go after these kinds of situations. So that's why I support changing the law, of course, getting judges in that will be more understanding of the history of the antitrust laws out of the Borkian mold, and much more in the model of Justice Breyer, who's an expert on antitrust. So, well, what can we do? The first thing as I look into next year is making sure that we stop this politicization of the Justice Department in general. I won't go there in a big way. I'll just focus on antitrust and some of the things we learned about recently from the whistleblower. I know that Mr. Delrahim has responded to those statements. He wrote a long letter to me personally that was then I think he later sent to the House. And he'll have a chance to talk about that when Senator Lee and I have our hearing in the fall. But stepping aside from that and just kind of looking at it in a bigger way, you know, this president's continuing attempt to act like he wants to do something about antitrust, but then just using it as a sword to go after some companies when he doesn't like them, or to go after CNN, that doesn't allow us or help us to pass new policies that would actually make a difference. And in fact, it undermines the work that career people would want to do on these issues at the Justice Department and FTC. It undermines their credibility because it makes it seem like all politics. And I think that was a point when we found out that a third of the second review budgets were devoted to cannabis mergers in the last year or so. A third didn't produce anything, but you think of all these areas, like I've mentioned, with online travel and tech, where we've seen mergers like never before, and in healthcare. The thought that that would be the focus of a third of the resources, however new this area might be, just makes no sense for many of us that have been trying to make a difference in these issues for a while. So it's bringing back the glory days of those agencies. Part of this is resources. Senator Grassley and I introduced the Merger Filing Fee Modernization Act, and it would update the merger filing fees for the first time since 2001 and increase appropriations to fund more effective enforcement. When you look at it, there were more people working there like during the Reagan administration, and he was not exactly a fan of antitrust. And so I just think that we need to look very carefully at the resources, because there's absolutely no way with a new president that we're going to be able to undertake the kind of investments and enforcements that we need to undertake unless there's more resources. Merger enforcement, updating the Clayton Act, and that's a bill that I have, the Consolidation Prevention and Competition Promotion Act, with a number of other Democratic senators. That would strengthen the legal standard. Those experts on the call, on the Zoom call here, will understand what I'm talking about, but that's replacing the phrase substantially with materially, to make it easier to prove up these cases, as more than to restore the effectiveness of the Clayton Act as a tool to stop the harmful consolidation. Clarifying, and this is very key, that mergers that tend to create a monopsony are illegal. And that, to me, you need to explicitly include the term monopsony in the statute to show that mergers that give a company the power to lower the prices it pays or wages it offers below a competitive level would violate the statute. Codifying the structural presumption for mergers, and this is for the mega mergers, shifting the burden of proof to the merging parties instead of the government, to show that they have to show that it doesn't materially lessen competition or create a monopoly or monopsony, as opposed to making the government prove the opposite. So I think that those kinds of things would make a real difference in getting this done. Civil fines, upping the civil fines could also help, because as we know, not everything is criminal fines. That's another bill that I have. And then also, we must make sure that we are using new tools to address anti-competitive exclusionary conduct. And that's a bill that I have as well, to reinvigorate enforcement against anti-competitive conduct and enable enforcers to protect competition across the economy. I have a lot of views about how we can get this done. I think there's Republicans that are interested in this issue. They've been very outspoken. Now they tend to focus sometimes more on individual companies, but the case should be made strongly that yes, there's tech issues with privacy, and there should be specific tech investigations, some of which are going on now, and there may be specific issues like monopsonies that are very focused on tech. But what I want us to do is step back and look at mergers and consolidations across America and how we can give our enforcers the tools. And that means, yes, resources, but it also means changes in the law, because anyone that thinks that they're just going to wait around for Gorsuch and Kavanaugh to change, while Kavanaugh made what I approved of in one decision on antitrust in the last year, when you look at their records, they are so conservative. They're more conservative than the court that's been there for years. And so there's just absolutely no way you're suddenly going to see this enlightenment to change the Borkian view that has really shifted down to some of the lower courts. And I'm not saying that there won't be some of that going on. I think there'll be sparks of change for antitrust. That's what you saw with that one recent decision. But that's just going to take years and years, and we don't have years to wait when you look at what's happening with startup slumps and income inequality and the like. And so that's why I've become such a devoted advocate for changing the legal standards and changing the laws and getting this done. I know your topic today is going to be the vertical merger guidelines, and I'm going to be brief as I know the panel is going to be discussing those guidelines at length. The new vertical guidelines are a much needed update to the outdated 1984 guidelines, but I have some serious concerns about not only the process, but the emphasis of the guidelines themselves. On process, significant changes were made to the draft guidelines that were released in January, yet they were finalized without the opportunity for further public comment and without the support of either Democratic FTC commissioner. To me, this sounds like a missed opportunity to improve the final guidelines and achieve a more enduring consensus, just as we're starting to see some bipartisan interest. Our hearing today in Judiciary, which was on judges and other things, started out with senators talking about antitrust and the hearings that Senator Lee and I are going to be conducting in the fall. So I think it's sad that they didn't use this opportunity to try to get that consensus. On substance, I was pleased that the agencies resisted the pressure coming from some commentators to include a presumption or statement that vertical mergers are genuinely or inherently pro-competitive. The public comments surely show that there is no solid factual basis for that position, but I am troubled by the constant references throughout the guidelines to the potential pro-competitive effects of vertical mergers. It is one thing to explain potential merger efficiencies. We know that, but the guidelines place far too much emphasis on the potential efficiency known as the elimination of double marginalization. It's mentioned in the document more often than the terms anti-competitive harm or consumers. When you look at what's really happening here right now with consolidation and the record number of mergers, and what we see now is we realize that many of these companies are buying what seems like small companies that could have no impact or a drop in the bucket, and then we realize, no, they're thinking ahead, to what's going to happen if they don't buy out that small company. So it's no surprise to see corporate law firms highlighting that the guidelines recognize that vertical mergers often generate consumer benefits, creating a promising path for companies to secure antitrust clearance. That is not my quote, that is someone else's quote. And that gives me much concern that these guidelines could prove to be a roadblock to the agencies if they try to challenge an anti-competitive vertical merger in court, or that they could weaken the government's negotiating position when discussing merger settlements. I appreciate the desire to be transparent regarding agency practice, but again, I have concerns that these guidelines may make vertical merger enforcement much more difficult than it already is, just at a time when people are crying out for change, and less effective and frequent than it could be under current law. I'm hopeful that the FTC's forthcoming vertical mergers commentary will focus less on touting the potential benefits of vertical mergers and more on identifying the types of vertical mergers that warrant enforcement scrutiny, including discussion of potential theories of competitive harm that were neglected in the guidelines, such as evasion of regulation. So I think we all know there is the mergers that are going to be coming before us, like a big train. Well, as you know, within the rail industry now, there are 4 companies that have over 90% of their freight traffic. I note that is the exact same number of railroads on the monopoly board. But as these merger approvals are going to be coming our way on these train tracks, we had better be ready. And I think the way you're ready is with the resources, with guidelines that work, and that we also are willing to not just look at the new mergers coming in, but also in what's happened with our economy and how we can look back at some of the decisions that were made before, including consent decrees and the like. That's because ensuring active and effective antitrust enforcement has never, ever been more important than it is now. For the antitrust agencies, this means increased vigilance and the willingness to enforce laws. For Congress, it means considering legislative reform to ensure that enforcers have the legal tools they need. So I just hope I have made my case that America is with us when you ask these questions, and do they think things are getting too big, and do they feel like things are out of their control? They say yes. Do they like some of these services? Of course they do. We are an innovative country, but America has always been based on strong capitalism and this idea that we are going to have a free economy. Right now, it's not free if small businesses are pushed out in either a monopsony situation or because of various reasons related to monopoly power. So I think it's time to make antitrust cool again, and I expect our panel to carry on my wishes. Thank you very much. Thank you, John.
Thank you, Senator. I can't thank you enough for giving us that landscape and your thoughts. It couldn't be better motivation for our panel. So we know you've got a very, very busy schedule, but we really do appreciate you participating today. Hope to do it again sometime soon. Thank you.
Okay, very good. We'll see you soon. Thank you.
I hope everyone enjoyed the thoughtful and maybe provocative remarks by Senator Klobuchar. We'll now turn to the panel. And here we've got a little bit of an embarrassment of riches problem. We have a renowned set of antitrust economists and lawyers who have collectively spent decades studying antitrust, doing research on antitrust, practicing antitrust, enforcing antitrust laws at the highest possible level. And so I will introduce them only very briefly, not to be a disservice to their distinguished careers, but rather just simply to give us a bit more time with them. So the way we'll proceed first is our first panelist, and I'll introduce them all and then we'll turn to them. Our first panelist is Renata Hesse. Renata is a partner at Sullivan & Cromwell. Prior to that, she was the acting Assistant Attorney General for Antitrust in the Department of Justice at the Antitrust Division. Renata has an undergraduate degree from Wellesley College and a JD from the University of California, Berkeley. Next, we'll turn to David Lawrence. David is the current chief of the Competition Policy and Advocacy section of the Antitrust Division of the Department of Justice. David has an undergraduate degree in physics from the University of Massachusetts Amherst and a JD from New York University Law School. We'll then turn to Bob Majure. Bob is a vice president of Cornerstone Research, and prior to that served for a number of years as the director of economics at the Department of Justice Antitrust Division. Bob received his undergraduate degree at the University of Virginia and a PhD in economics from the Massachusetts Institute of Technology, MIT. We'll then turn to Andrew Sweeting. Andrew is currently the director of the Bureau of Economics at the Federal Trade Commission. Andrew is also a professor of economics at the University of Maryland. Andrew received his undergraduate degree at the University of Oxford in England, and also received his PhD in economics from MIT. We'll then lastly turn to Mark Widener. Mark has worn many hats. He most recently, currently is serving as a Senior Industry and Innovation Fellow at Georgetown University's McDonough School of Business in the Center for Business and Public Policy. He's also there an adjunct professor where he teaches competition policy. Prior to that, Mark was the Global Executive Counsel for Competition Law and Public Policy at General Electric Corporation for a number of years, and prior to that served as the Deputy Director of the Bureau of Competition in the Federal Trade Commission. So we have a wonderful panel, as I indicated. What I want to do is turn to them. While they are each in their own ways tremendously distinguished, they also have slightly different perspectives and nuanced experiences. So let me turn first to Renata, and I'll ask this same general toss-up question to everyone, but just Renata, if you could get us started on your thoughts and reflections on the new vertical merger guidelines. What's the role? Was the update needed? Are they helpful? Are there features of the guidelines that are notable for their inclusion? Are there features of the guidelines that are notable for what's not there? Renata, what's your impression of the guidelines?
Great. Thanks, John, and thanks to Cornerstone for having me. This is a great session, and it was fun to listen to Senator Klobuchar's remarks. So the guidelines needed to be updated. There's really no doubt about that. They were old and outdated, and I think when you think about them in a funny way, the kind of theory underlying them is still good theory. It's just that the way it was articulated and described in the old guidelines, I think was way out of date. And I think the agencies did a really great job of bringing them into the 21st century and really making them more modern and reflecting the economics that comes to bear when we look at vertical transactions. I think people on either side of the debate, there are those who think that all vertical mergers are pro-competitive. There are those who think that they can pose real harm. And then there's a vast swath of people in the middle that recognize that some are good and some are, can be harmful. But I think, people on either side of the debate were really hoping for more clarity. So notwithstanding Senator Klobuchar's comments, something more that would say, well, generally we're gonna think they're okay, or actually generally we're gonna think they're gonna be harmful. And I don't think either side really got that. And I actually tend to think that's a positive. And I don't think it's the fault of the agencies. I think it just reflects how fact-specific and case-specific vertical merger enforcement is in reality. So I don't think that they actually give a lot of guidance to the public about what kinds of transactions are likely to be pro-competitive and what kinds of transactions are likely to be harmful. And, at their best, that's what guidelines do. They help business and lawyers and enforcers kind of better understand which kinds of factors are going to matter in the analysis that the agency undertakes when they face the review of vertical transaction. And, when people are advising clients about the regulatory risk associated with transactions. So, I think they don't help tremendously in that regard, although I think they do accurately describe what the agencies do and what they think about when they're looking at transactions. And the other thing that they guidelines do, and again, I'm not so sure that these guidelines will help in this area, just given that they kind of don't stake out a position, is that they can help courts work through complicated cases and understand the analysis that the antitrust agencies are asking them to undertake when they when they hear these cases, which can sometimes be complicated and sometimes pretty confusing given all the economics that gets thrown at judges that aren't typically trained specifically to hear these kinds of cases and deal with the models, the sophisticated models and things like that. So I like what they have in them, and that I think they are descriptive and helpful in that regard. I don't think that they tell people much about how to navigate or how to advise clients to resolve this question about if I do this transaction, am I going to run into a lot of trouble, or am I likely not to run into a lot of trouble? A couple of other points. Bob's going to give me a hard time for saying this because I said it before and he made fun of me about it, but it does suggest I'm a little bit old-fashioned. But I think that the lexicon of relevant and related markets, I just think it's really unnecessarily complicated. I understand why they did it. I just feel like it kind of made the guidelines more confusing. The hypotheticals help, but I wish they had stuck with what people normally talk about: upstream, downstream, those kinds of things. But maybe I'm just a kind of a simpleton lawyer in that respect. And that's really more of a pet peeve than anything else. But the other and much more important thing that I'd flag, and Senator Klobuchar flagged this as well, is that while I think it is really good to cover the elimination of double marginalization as a feature of vertical mergers that might put a thumb on the scale towards approving a transaction, I don't actually think that the economics in practice is really all that clear. And when I say in practice, I really mean in practice. I think the theory is actually very clear, but I don't think there's a lot of data and study to suggest that anyone really knows that EDM is always or often or even only sometimes realized. And I think that there is a way in which the guidelines suggest that one should maybe think that it kind of almost always happens, and I'm just not sure that the evidence is really that clear on that point. Which again is not to say that EDM isn't real and it doesn't happen or it never happens. It's just that it does feel to me like there's a little bit too much emphasis on that as a potential counterbalance to harm. So those are really the main thoughts I have on them.
Renata, thank you very much. We'll circle back with everyone. Let's go ahead and press ahead. David, if you could offer a few of your reflections on the new guidelines, please.
Thanks, John. And I should say it's also such an honor that we had Senator Klobuchar here. We at the Antitrust Division have been fortunate to have her on the subcommittee. She really has been a thought leader in this space. Also an honor to follow Renata, who I had the privilege to work for when she was AAG, and that's actually where I first started to get into the depth of these issues. So great to have them both here. I thought I'd just answer today a couple of the really basic questions on the vertical merger guidelines. Why and how, from the perspective of someone who worked with them on the agency side. The reason why is fairly simple, and I think we've been over. Simply put, to the uninitiated, so let's leave aside people who get invited to a panel like this, the agency's vertical merger enforcement approach has been completely opaque for several decades. And maybe even worse than opaque, because the 1984 document is kind of deceptive in some ways. So you really, for a number of decades here, have needed to be an expert insider or hire one in order to have an idea of how your vertical merger would be reviewed and how the conversation would play out with the agencies. And so that's just not good government. And so that's really one of the most important functions of guidelines. It's not the only things guidelines do, but one really important thing they do is provide transparency. And I don't need to go over here why transparency is valuable, but I mentioned two audiences I think it really helps. First, it obviously opens things up to the non-experts, right? So business people, less experienced counsel, maybe some of the thousands of people who tuned into the hearing yesterday. I mean, my mom asked me after yesterday's hearing about antitrust for the first time in my career, right? And those sorts of people can go to our website now and at least know something about what we do in vertical merger enforcement. Really important. I also think transparency in a document like this is good for the experts and for the policy wonks because it opens up our processes to a public debate. It provides a shared framework for what the debate is about, right? Issues like elimination of double marginalization are discussed in the document, and I think that informs a broader public debate about them as we continue. So there's a lot of whys, and I think some compelling whys for why we did it. I should also address why now, right? And for those of you who don't know the history, it's actually been the case, I think, since the 1990s that antitrust experts have recognized that the prior guidance was sort of out of sync with agency practice. And there have been widespread calls for revision or a new document since then. I'll tell a quick story on that. When I came into this position, my predecessor was a longtime chief of the section, Bob Potter, who'd been there for 25 years. And one of the things I learned is that he kept meticulous files. On every issue, he had a file with basically every time an AAG had asked him to write a memo, you know, it was in there and they were all stacked up. So when I wanted to get up to speed on this project, I went and got his file. We have these paper files on vertical merger guidelines, and it was really thick. Because what it had in there were the records of several prior efforts by the agencies or by the DOJ to update this guidance and put some transparency out there. It was actually sort of intimidating to come across because it underscored how challenging this project was going to be. And I'll say, I think it's gotten more challenging as decades have passed without an update. So that brings me quickly to some of the how. And I'll raise three things that I think were indispensable to this project this time around. First of all, the relationship at the staff level between the DOJ and the FTC staff was tremendous. I can tell you in the trenches, Andrew is one of several folks we got to know at FTC. I should mention Bilal Syed and Allison Oldale and a lot of others who we got to know, and we had a team at DOJ. And I think everyone had a great attitude and worked well together. So that was really important. Second, the comment process was incredibly robust. We got more than 70 comments from interested parties that were both deep and broad in their coverage of vertical merger issues. Those comments are on our website, and I think for folks interested in this, that collection of argument and analysis is about as complete a collection of analysis on vertical mergers as has ever been done. And so that was really helpful. One thing I'll say we did when we were poring over those comments is we kind of sliced them up by issue areas. So we had a few people put this together. So on just over a dozen different issue areas, like elimination of double marginalization or the safe harbor, we reorganized all the comments by, you know, who had what to say on that particular issue. So when Renata talks about the spectrum of views, you could see that on a particular issue, you know, in this document we prepared. And it really did underscore that there is a fairly wide range of views on a number of policy issues related to vertical mergers. The third thing I think that was important to the how here was, especially because of that continuum of views, we had very clear marching orders within the antitrust division from the AAG that these guidelines should reflect the actual practice as it exists today. It was really a transparency, a window into what we do sort of mindset. And so that gave us kind of a lodestar for resolving a lot of these issues. You know, we'd look at this continuum of views on a policy issue, and our job wasn't to say what the one right answer is for all time, but rather to just say, you know, we've worked on cases recently. We can talk to people who've worked on cases recently. How do they think about it? And that was the way we narrowed the debate in order to prepare these guidelines, just that, you know, going back to that transparency piece. So that's a little bit of insight into what we've done, and I can share a few more specific stories as we go.
Thank you very much. Before we move to Bob, let me just quickly ask something that got my attention. You spoke about the process of having external comments. And what I was thinking is that there's a counterpart. I'm not asking for you to reveal trade secrets here of what goes on inside the Department of Justice, but there is a footnote in the guidelines I have to mention. It's footnote 1 of the new guidelines that says that the guidelines, and here I'm quoting, reflect the ongoing accumulation of experience at the agencies, that they reflect the ongoing accumulation of experience at the agencies. So I guess my question to you is, if we've incorporated these various comments from outside the agencies, how do the new guidelines reflect that accumulation of experience within the agency?
Sure. I mean, so in terms of mechanically, it's just by knowing people on the various case teams, working with them internally, of course. But I do think that footnote underscores that a really important means by which the agencies develop policy and analysis is in the trenches of particular cases. I mean, we have really smart lawyers and economists. They work really hard on tough issues in particular cases, and they so often move the ball forward. And I think part of what that footnote is trying to get at is that we don't see these guidelines at all as an endpoint to that process of case-by-case advancement. And we were really clear with the staff as well as we released them that we just wanted to give a public window into the evolving case-by-case analysis that they're all continuing to do even today in cases that we're working on.
Wonderful. Renata, again, just a brief interlude here. You used to be at the Department of Justice. You are no longer there. Is it your sense that the new vertical merger guidelines accurately reflect the accumulated experience of the various cases that you had while you were at the Department of Justice?
So I think, to echo Dave's comments, I think that there's nothing in them that I would recognize and say, oh yeah, that's that case, that's how we handled it, or here's a hypothetical that's that matches up some factual situation that that we saw in a given transaction, and I actually think that's good. I think it's good for it to be a little bit removed from that, but I do think they reflect the the process that the lawyers and the economists and the division go through when they're looking at these transactions. And I think they reflect that accurately. But there's a lot of, weighing of facts and balancing of features and, efficiencies versus EDM versus, how do you measure raising rivals cost? There's lots of sausage that goes into, or sausage making, I guess, that happens when you're reviewing one of these transactions. And I think the guidelines kind of give you a nice superficial, and I don't mean superficial in the negative sense, but a superficial look at what that process looks like without really digging down and saying, here are the tricky questions and here's how we struggle with them. And I think that is as it should be.
Okay. That's completely fair. Let's turn, Bob, if we could turn to the economists, begin the economics portion of this panel. Bob, as I mentioned, was the director of economics at the Antitrust Division for a number of years. You've had a lot of experience with guidelines. What's your reaction to the latest new vertical merger guidelines?
Yeah, well, as somebody who worked on most of those attempted vertical merger guidelines that were in Bob Potter's file, I really have a deep appreciation for the accomplishment here. I know I had gotten to a point where I thought this was unlikely to ever happen. And I think one of the things I would emphasize is that the reason those earlier guidelines had failed, those attempts had failed, was largely that they attempted to kind of find a commonality among vertical mergers that we're used to in horizontal, but vertical has so much more differentiation. There's so many more ways that a vertical story can play out that it's really hard to find that. And it's really a great accomplishment, a great step forward that these guidelines highlight what the agencies really do in practice look for, which is this incentive and ability coming together as a result of a merger. And so while I think that's an enormous step forward and it's great to have shown that it is possible to have vertical guidelines, I still think there are a lot of additional steps that we can take. And I want to comment on some of the things that I think, maybe are room for the next step, and looking forward, places I'd like to see us, not with an immediate rewrite of these guidelines, but, as we kind of do research and think through where should we be going, there are a few things that jump out at me. And one of them, probably the most important, is that there's a piece of the practice that in my experience was always as important or more challenging for the agencies than just identifying the incentive and ability. And it's a little bit referenced in the guidelines when they talk about analyzing that incentive and ability with consistent models where possible. The challenge is making a prediction that the incentive and ability, which generally exist prior to the merger, but in separate companies, are going to be brought together by the merger in a way that couldn't have happened without the merger. This is often, in my experience, done by reference to if firm A were to eliminate all of firm B's rivals by making firm B the only distributor of its product, that would clearly be an antitrust problem if firm A and firm B are separate companies. But it wouldn't be a problem necessarily if they're integrated, if they're one company. Now, that what I tend to think of as an antitrust regulatory evasion story is maybe focused on antitrust. Maybe lawyers who do antitrust tend to focus on the contractual difficulty they know best. As far as I know, there's nobody who's ever become an antitrust attorney of note after a long and distinguished career as a contract attorney. Maybe the agencies actually are intending to address this issue that is kind of fundamental to vertical mergers. What can you accomplish through contracts by addressing this missing expertise? If so, that'd be very interesting, because I think that missing expertise has been a big factor in how the agencies think about behavioral remedies, because behavioral remedies are essentially writing a contract, and antitrust lawyers, as I said, aren't necessarily skilled at writing contracts. But I don't think that's what they're going to do. And in that vein, I think it's telling that regulatory evasion as a whole is one of the theories that was in the 84 guidelines that has been left out in these guidelines. And the stress on raising rivals costs and foreclosure as the theories that are most often seen by the agencies really does kind of suggest that some of this detail on how the agencies are going to deal with or have dealt with this consistency element in their practice is kind of an opportunity missed. And I think that's related to some of the concerns that I have still about the treatment of EDM. It's been great to see that that's moved out of its own section, but the emphasis on eliminating double marginalization, because of the fact that it is it's derived from the same relationship to price that motivates the foreclosure or raising rivals cost story. That's true, but it means that in some sense we're saying being of the same story matters more than another efficiency, another aligning of ability with the incentive to accomplish an efficiency that might be from a different kind of relationship effect, or might even be at a completely inconsistent basis. For example, if the reason for doing a merger is to accomplish an efficiency that requires working more with rivals to firm B, then I can kind of only accomplish one. I can foreclose all those rivals and drive them out of business, or I can work more with them. Somehow that has to be taken into account when we're dealing with the consistency element or the proof of the change due to the merger. And it's kind of discouraging that that's been subsumed in the guidelines behind this idea that one type of efficiency matters or counts, and the rest, because they aren't fitting this criteria of being in the same element, don't count as much. So I think this is a place where more work is definitely needed to kind of tee up how do the agencies deal with this consistency element, and in particular, how does it is the same element in terms of an anti-competitive effect and an efficiency or pro-competitive effect of a merger. How is it being resolved in terms of making a final prediction, which of these is the more likely outcome? I think to that end, it's also a little bit worrisome that the other way these guidelines have managed to solve the issue of the diversity of theories out there in the vertical world is to focus on just a few examples, and to say that those examples of particularly foreclosure and raising rival's costs are kind of the ones the agencies see most often, because I think that hides a lot of the important complexity of vertical mergers. And when you're kind of dealing with it from the outside as, you know, what might they be investigating, it's very difficult to know which theories might apply. If to the extent these guidelines focusing on one set of theories or one family of theories is going to kind of center that attention on that one story, I think it's troubling, because that highlights more the role of the assumptions in a model, the arguments people make about it, and the preconceived notions they have that go into whether those assumptions or what kind of assumptions matter. That's already a problem in vertical analysis. One of the factors that this great diversity of possibilities in vertical relationships introduces is that the results aren't like we're used to in horizontal effects, little nudges around what the equilibrium of prices would be. We're not seeing small changes from the business reality that mean that documents we see ordinarily do relate just as well to the new equilibrium. They're existential questions for some companies, and that means we can't give courts nearly the evidence of what's going to happen if this merger goes through that courts are used to in evaluating, you know, how credible is this claim. That leaves just the assumptions of the models, the logic, the arguments, or the skill of those making the arguments, and it leaves preconceived notions as a big factor in how these are weighed and assessed, both by the judges and by the agencies as they kind of decide whether to bring a case or not. I think if to the extent these guidelines are going to accomplish the stated goal of trying to inform judges or form a basis for evolving a judicial standard on vertical mergers, I think it's necessary, whether you think that enforcement interest is too high or too low, or somehow you're one of the few who thinks it's exactly right. I think dealing with this lack of engagement between the facts and the assumptions, and the central role that a few sets of assumptions have tended to play in thinking about vertical cases, is going to be a critical next step. Having said all that, I think we only get to take these next steps because of this accomplishment of actually getting guidelines that do, for the first time ever, uniquely deal with vertical mergers. And so I offer, you know, great congratulations to everybody who is involved in getting these out, because I think having taken this step, I'm excited to see where we'll go next.
Bob, thank you very much. There's just a lot to chew on with your remarks, and hopefully some of the questions from the audience will get to that. But in the interest of pressing us ahead, let me turn to Andrew and tee it up. Andrew, you got to see the development of these guidelines in a real-time fashion, and it just will be very interesting to hear your thoughts and reflections on the guidelines.
Okay, John, thank you very much for yourself and Georgetown putting on this event today. Before I begin, I should give the standard disclaimer that I'm participating today in my personal capacity, not as a representative of the Federal Trade Commission, and the views I'm going to express are my own, and not necessarily those of the Commission or of any individual commissioner. So as background, you said I was involved in the process. So I actually joined the Bureau of Economics the same week that the draft guidelines were issued. So I kind of read them as almost as an academic outsider, and then got to see, you know, both some of the reasoning obviously behind the draft, but also kind of how it evolved over time. And as Dave Lawrence said, you know, it really did benefit tremendously from lots and lots of comments, you know, we received, both from academics, attorney generals, and other regulators such as the FCC. And there was also, as Dave also said, you know, a very collaborative effort between the lawyers and the economists at both agencies, which was great to be a part of. So let me kind of address some of the questions that have come up, both in your question, John, and also in some of Renata and Bob's comments, by saying something about, how economic thinking about vertical mergers has kind of evolved over time and how the guidelines fit into that, and also why I think hopefully this can help, the guidelines will help the process of answering some of the unanswered questions which Bob raised. So, when the non-horizontal merger guidelines were issued in 1994, that was exactly the time where a real kind of set of breakthroughs in how we economists think about vertical mergers and vertical issues more generally actually took place. So I think it's useful to contrast this with how we think about horizontal mergers, where the basic logic has been around for generations. Or what has happened, the way I think about it, is that we've expanded the set of models that kind of that logic applies to, such as for auctions and for bargaining. And we've come up with new tools and models to think about how to predict those effects. But the underlying economics are basically the same. That's kind of different for vertical mergers. So, if you think about kind of classic articles, so Salop and Shefferman's Raising Rivals cost paper was published in 1983. And then after the non-horizontal merger guidelines, you get kind of Mike Salinger's vertical foreclosure paper in 1988, Kraftmacher and Salop's kind of work on exclusion, and also work on other vertical issues such as exclusive dealing and vertical restraints. You also see exactly the same thing happening on the pro-competitive side of the ledger. Okay, so while EDM had been understood, for decades, its kind of application more in oligopoly settings really starts breaking out in the late 1980s. And also, if we think about the kinds of investment efficiency, which Bob was mentioning, figuring out how economists think about whether those things can happen in separate firms or whether they'll only happen within a single firm really starts to happen in the incomplete contracts literature with the work of kind of Oliver Hart and John Moore, once again in the late 1980s. Similarly, that's when you see kind of Asher Walensky and other people's work on vertical bargaining models, which are now providing kind of the workhorse for a lot of the bargaining analysis the agencies do. Okay, so what's useful to take from that chronology? So I think it just tells you the 1984 guidelines really couldn't capture the way that we think about vertical transactions now. And I think that in of itself is a good reason to try and replace those guidelines. The second one is that actually new learning can actually take place quite rapidly, right? So I think if you think about what we understood about things in 1980 and what we were understanding things by the mid 1990s, there was really a dramatic change. And I think that tells you, we can expect our thinking on some of these issues to continue to evolve. And what I would hope is that maybe some of the work the guidelines do will help crystallize particular issues for people to work on, right? So the kind of example might be, can we find ways to make predictions about what will happen, when you have both kind of foreclosure incentives and EDM incentives in a way that is less tied to some of the assumptions that Bob kind of mentioned and can help give us kind of more robust predictions. The third thing is that all the papers I listed are really kind of theoretical investigations, right? And actually the empirical learning on vertical transactions in the academic literature is still quite thin. Okay, so just if I can take one example from both the 84 and the 2020 guidelines, there is a discussion of kind of how vertical mergers can create the need for two-level entry. And intuitively, that's going to make two-level entry, potentially more, two-level entry may be more difficult, and that might create an anti-competitive effect. Well, even though there's been a huge amount of work on kind of entry models and economists thinking about entry in the last 30 years, there's kind of been no moving the ball forward on that question. So I'm not aware of any academic work investigating two-level entry, either in general or in some specific context. Right, so I think, to do some of the things that I think Bob was talking about and Renata was talking about, we're really going to need kind of more empirical work. And then hopefully we won't have to wait another 36 years to kind of update a guidelines that can include some of those insights. The other point I wanted to make was that I do think it's valuable to say we are going to analyze kind of EDM and raising rivals cost pricing incentives in kind of a single framework. right? They're both pricing incentives. They interact with each other. So the size of EDM will affect the size of kind of RRC incentives and vice versa. And I think, to say we're going to do that in a single structure whenever possible, I think makes, a lot of sense. I agree with Bob. You also want to understand how RRC affects investment incentives. And I don't think that's being taken off the table by what we say in the guidelines. It's just a recognition that analytically, that's often kind of a much harder problem. Okay, so now I'll let you get back to the discussion so we don't lose too much time.
Very good. Again, a lot to think about there. Great chronology of the economic literature. Mark, let's turn quickly to you so that we can then, in a few moments, turn to questions from the audience.
Sure. Thanks, John. And hi, everybody. I'm just going to talk briefly about the guidelines in terms of the audiences at which they're aimed, which is a useful way for me to think about it. So first and foremost, the guidelines say that they're aimed at antitrust practitioners and businesses. And for this audience, I think I agree with I think David and Renata. The insights in the guidelines are essentially already known to experienced practitioners, but they have to kind of piece it together over time, from speeches, from investigations they've been involved in. If they happen to have been in an investigation where one of these issues is raised, then they can repeat that the next time. So I think collecting all of that in one place, clearly useful. And from my experience, most of the guidelines do actually track investigation theories that are and have been employed in practice. So that's useful. And no major analytical twists or surprises, with one exception that I'll come back to. The second audience, and the guidelines also identify this as an intended audience, is the courts. Here, I also agree with earlier comments that it's useful for, I think Renata said, for judges to have a relatively simple exposition of the theories, the fairly complex theories that may be thrown at them in a case the likes of which they may see that one and only time in their judicial career. So that's useful. But I would say, unlike the horizontal guidelines, in my view, I would not expect the vertical guidelines to be particularly impactful in terms of shaping judicial doctrine or shaping outcomes in any particular case. And that's because if you look at the history of vertical merger litigation, of which there has been relatively little, in fact, quite little, the last several attempts to litigate these cases over the last several decades have all failed. And I would say, if you look at them broadly, they've failed not in the main due to big disagreements about the legal standards or economic theory, but really concerns about the facts that the government alleged. So, and the guidelines are not particularly going to move that discussion. The third audience that I think is worth calling out, and this is an implicit audience of the guidelines, but the guidelines are part of the broader policy debate in which we are now immersed, of which yesterday was a big part. And here I would say, I think the guidelines are particularly useful, although that value may be short-lived when you look at some of the reactions to the guidelines. But I think the useful thing they did in summarizing the analytical framework was to remain essentially burden neutral and free of presumptions. I say that because, well, for a lot of reasons, there were calls from both sides to create presumption safe harbors that would have been either tending toward more or less intervention. And I think the agencies wisely refrained from that. The document stands on its own as analytically, I think, largely correct. The guidelines could, in a bipartisan environment, survive changes of administrations who may have more or less interventionist urges, because the guidelines can be interpreted fairly broadly. I mean, I think if you look at the economics underlying the guidelines, and if you look at the litigation track record, the agencies would have been justified in being somewhat more tilted toward emphasizing pro-competitive benefits from vertical mergers and describing some of the limitations and some of the competitive effects theories. But overall, I think the neutral, burden neutral, presumption-free approach was the right one. They've been criticized for it. The calls to throw them out and start over reflect some of that criticism. I'll just briefly mention the one substantive criticism I have, which we can come back to if we like. In the last version of the guidelines, they threw in this theory of harm from mergers that are not vertical but involve complementary products. And while these are theories that the agencies have employed in some investigations, they haven't led to much in the way of enforcement. I think this is a situation that would have benefited from public comment. The conditions where such harm is going to be found are very narrow. And the other important point is it's extremely hard to anticipate from a pre-merger stance when a merger might create the likelihood of some kind of bundled pricing harm. If that conduct occurs post-merger, it can readily be identified and investigated. So I think that's a reason why it might have been useful to discuss that a little bit further before it was added to the guidelines. And the final point I'll make, and we can again return to it, John, if you'd like, is that of remedies. The agencies have consistently viewed remedies separately as a policy matter from substantive guidelines, and there are good reasons for that. But with vertical mergers, I think the theories of harm and the potential remedies are very closely linked, could have been valuably discussed in these guidelines. And there also is some policy divergence between FTC and the DOJ that I think is going to need to be resolved at some point. So that question was left unaddressed.
John, could I?
Mark, thank you very much. I would be ordinarily tempted to go back and ask another round of questions to all of you. There's certainly a lot to chew on, but first maybe we should give an opportunity for the people in the audience to ask questions. Again, I'll remind you that my colleague, Professor Jeff Macker, is curating those questions. And Jeff, you may let us know what folks in the audience are thinking. Questions for the panel.
Sure. Let me present the first question. It came in at 12, so it was in relation to the senator's comments, I believe, about the big tech antitrust hearing. So take it, the panelists, in that context. The question's two parts. First, how important is it for law enforcement agencies to bring cutting edge cases, even if they may lose, in order to develop the law? And then second, is that an appropriate use of resources? So the idea, I believe, behind the question is, should big tech be scrutinized, given that it's more of a cutting edge case than otherwise?
Want me to take a shot at that, John?
Sure, Renata.
I actually do have views on on this topic. I do think it's a reasonable question to ask. I think what is very hard to know is what you will do to the law when you do that. And I think that's why agency heads often refrain from kind of, I'm putting this way too colloquially, sort of taking a flyer saying, I believe that this is the right thing to do. I'm not sure the law is with me. I'm going to go take a run at it in court, and we'll see. Hopefully, the court will agree with me, but but maybe they won't. You might end up with a really bad decision, and if you're really trying to advance enforcement in that area, you actually could end up taking it in the other direction, which can be a little bit scary. So it's very hard to make those decisions when you're the decision maker and you're sitting in the chair and you're trying to figure out whether to bring a case. And as a consequence, I think most of the time people bring cases that they think they can win. They're not always easy cases. In fact, most of the cases that the agencies litigate are hard cases. But I don't really think it's a great idea to kind of experiment with theories in court, because I do think you can end up with making the law worse, and then you're stuck with that for a while until you get a circuit split, and then you have to go up to the Supreme Court. So hopefully that answers the question.
It does. Any other panelists want to chime in there? If not, there's two questions that I'm going to try to combine on how hopeful are you regarding the durability of the vertical merger guidelines. So for instance, in 2010, the horizontal merger guidelines were updated and supported unanimously by the FTC. This isn't true with the vertical merger guidelines. And then if you don't consider that, another question is, in an election year, how durable do you hope these guidelines will be? And that's open to all the panelists.
Let me jump in and ask this a different way to put you completely on the spot. Suppose you were the Las Vegas bookmaker establishing an over/under on the life of the vertical merger guidelines. Bob, what's your over/under?
Over under, I would
Last
probably
time was saying 36 years.
over under. I would probably say at least 15 years, because I don't think there's. I mean, to get at this, you're really the question is, what are guidelines, right? If they're supposed to be describing practice and they're supposed to be giving guidance to the business community about what's likely to happen, that's not where you move the law. I mean, yeah, Renata's just talked through how difficult it is to move the law with cases. You know, if that's the dispute, if that's the disagreement, that, you know, we've got preconceived notions on either side that say, you know, you got it. If both sides are saying you got it wrong, but you're describing what you're doing in practice, I think that's going to stay what you're doing in practice until you have something else that really shifts what the law should be or how courts interpret it. I think it's going to take a long time getting courts familiar with how to even draw parallels or connections or what the underlying fundamentals are of a vertical case before your argument can be clearly about why the facts of this one should push the law somewhere else, or whether pushing the law somewhere else is going to create issues for another case with different facts. And I think we're in such an unsettled state that really these guidelines should not be anybody's front and center target for these have to be changed. You know, there's got to be better uses of political capital than that.
Yeah, John, if I could just chime in on that. I mean, I think the first two questions kind of can be fused in a way. I mean, what is the right way to evolve policy if you're an agency? And I think I agree with the sentiment that you don't do it through enforcement guidelines, because those really should reflect what's being done. On the other hand, you don't do it by bringing a novel case that no one could have seen coming. That doesn't seem fair. So what do? I think the agencies have a bit of a practice of presaging what they're doing, maybe with some speeches. This is a new way of looking at an issue. The FTC did it with the reverse payments, for example, back when I was there. And then you start bringing cases and then you see how they go. I'd like to be optimistic that these will be around for a while. And I would echo Bob's sentiment that, you know, tossing them out right away, let's assume if there's a change of administration, doesn't seem like very good practice. Live with them for a while. If you have some things you want to do, you've got the flexibility and the guidelines to do it, frankly. I mean, given the footnote and the rest of the open-endedness of the document, which doesn't purport to close off really anything that makes sense.
Okay, we're not getting a lot of questions. There is a low priority question that an anonymous attendee indicated, but Mark, you said something about current academic work on entry and something else, and they're curious what that something else was, that there is not, in fact, any current academic work on entry and something else. You remember what that was?
I don't think that was me.
That was
Andrew,
I think
Andrew
that was my
referred to the-
question.
yeah.
That was what my comment. So
Okay, sorry.
yeah, I mean, I was just talking, you know, obviously there is a fair amount of academic work thinking about entry into particular markets, but this question of kind of two-level entry and the idea are there sometimes firms that would need to enter both downstream and upstream, particularly if rivals are vertically integrated. And does that make entry overall less likely? That's something that that's kind of a hypothesis that's in there in the 84 and the 2020 guidelines, on which I have not seen kind of any empirical work. You know, similarly, you know, some of the questions that, you know, both commenters have brought up, you know, commenters when we put out the draft guidelines and have been raised on the panel today, you know, things to do with, you know, EDM, you know, clearly that's theoretically a very clear concept. How empirically that plays out in different contexts is something where, you know, more empirical work would be very valuable.
Great. So Richard Clark just asked a question. The senator suggested that vertical and other mergers should be examined globally, not looking just at the effect of competition in the particular product market, but also looking at its effect on local labor markets, markets for innovation, et cetera. In contrast, the panelists have generally discussed guidelines with respect to standard economic and legal, streetlights, EDM, RRC, et cetera. Do the panelists believe mergers should be evaluated in a more global fashion? If not, why not?
I might just jump in briefly. And, you know, the question is phrased in sort of an analysis like narrowly within the product market, but the guidelines describe there could be many relevant product markets, even in the context of a particular transaction. Specifically on the labor question, the division has undertaken a number of initiatives related to the analysis of labor and antitrust. We held a workshop last year that I think had a fascinating discussion, and Doha Meki, who's been focused on labor issues in AAG Delream's front office, testified on Capitol Hill about it last year. I would flag within the guidelines, it doesn't say labor specifically, but on the second page, there's a paragraph there that references being concerned about market power by buyers, monopsony power, and I do think of that in the same vein when labor conversations come up. And while I have the floor, I should say Andrew's conversation reminded me that I neglected to give the standard disclaimer that I think, like him, my remarks are my own and don't necessarily reflect those of, in my case, the United States Department.
So can I add just a little bit on that? Because it, I've seen firsthand, and Canada has a law that actually tries to push for more of a total welfare kind of standard and tries to bring in all these related effects, both on the efficiency side and the competitive effects side. The problem with that, when you go farther afield than Dave's answer of, the guidelines ought to reach all your trading partners, and to the extent you can measure kind of an impetus for an effect on any trading partner that's relevant, there's a question of what do you do if you have a clever monopolist, monopsonist, who spreads the harm around enough. But aside from that, the only thing you really gain by trying to write these larger laws is confusion, because you get into standards that are really, economists realize these are standards about general equilibrium, where once you start to tinker with what people are doing and the choices they're making, there are ripple effects that can be dramatic and extensive. And trying to weigh those is very hard when all our tools are about what economists would call partial equilibrium. We have a whole economic framework for thinking about mergers based on the impetus to change and the incentive they create to do things different in the first instance, and not tracking them through to every effect that has on every other related market. It's not that those don't happen, it's just that we have, by focusing on the partial, we've kind of let that stand as the proxy for the greater effect that competitive considerations have on the economy as a whole. Trying to go to general equilibrium is very dangerous, because economists who tell you they can model general equilibrium are lying to you. It really is virtually it is an impossibility theorem that you can model this. And if we try to introduce that to something that's already struggling with, we've got to then explain all this to a judge. I feel like that's just taking things in absolutely the wrong direction.
Andrew, did you want to add anything to that?
Not really. I mean, I think I would say that the guidelines, as Dave said, certainly allow us to think about kind of buyer power and kind of upstream effects, including in kind of labor markets. And that's also been, concern about those markets has been something that's ongoing at the FTC as well.
John?
Let me jump in and remind people that we're now at the witching hour. It's 1 o'clock, and we've had a full, robust discussion for an hour and a half. I hope it's been incredibly provocative for you. I will simply close with thanks to Senator Klobuchar in absentia. It was great to have her on board. And a special thanks to the panelists, Mark, Bob, Renata, Andrew, David. Thank you very, very much. And thanks to Cornerstone for its valuable partnership in this. It was terrific to be able to do this together. Jeff Macra, thank you very much for all your help. Thanks for all the work that went into this. And please do stay tuned for future events down the road. Thank you very much.